Hi, everybody. Welcome to this webinar by ORH in English, I think. First of all, I have to recognize that my English is not perfect, but I'll try to do my best in this session. I think it's important to use these sessions to improve some other skills, in this case, English, apart from the subject to talk about. And that's why we have programmed this session in English, and that we are talk about Brexit. I think is very opportune. Oh, okay. My name is Maite Sainz, from those that doesn't know me, and I'm the director of this platform focused in HR knowledge and innovation. We're going to talk about Brexit and how to manage immigration options, and also health assistance and social security aspects. Our speaker is Linnea Larsson from Hess Document, who knows all about this in deep. I reminded you that questions can be sent during the speech and also by email to my email. Okay, Linnea, welcome, and it's up to you.
Thank you,
I'll
Maite.
give you the control, absolute control.
Perfect. Thank you so much. Good afternoon, everyone. As Maite indicated, my name is Nea Larson. I'm a manager at GD Global Mobility. Today, we will be discussing very briefly, due to the amount of information and the limited time, everyone's favorite topic, Brexit. At this point, you know that the UK no longer forms part of the European Union and that the transitional period has ended. But do you know the exact implications of the withdrawal agreement at this time? As a reminder, this presentation will be completely in English, but please feel free to raise your hand if you wish for me to slow down a little bit, or you can reach out afterwards as well. For those not up to date with the current situation, here are the key dates. As you can see, it's been nearly 4 years since the formal communication for the UK to leave the EU was made, but the UK formally withdrew from the EU only last January. In preparation for the end of the Brexit transition period, Spain established a new procedure for British citizens arriving through the end of the transition period, which we will look at briefly, as well as a simple modification procedure for those already residing here, effective starting July 6th. Finally, the transition period ended on December 31st, 2020. There are many implications from Brexit, the withdrawal agreement, and the EU-UK trade deals. However, today we will specifically be looking at immigration for British nationals and their non-EU family members, international social security and healthcare, as well as professional qualifications. First, we will be looking at the impacts on immigration in Spain, as well as a brief mention of the immigration procedures in the UK. To start, I want to clarify the current situation for British citizens and their family members in Spain, beneficiaries of the Brexit withdrawal agreement. Under this immigration regime, the holders maintain the same rights as they had as EU citizens in terms of the right to reside, to study, and to work in Spain. The first scenario is for British citizens who process their EU registry certificate, the green card you see on the slide here, before July 6, 2020. Having this card automatically includes the holders as beneficiaries of the withdrawal agreement. The Spanish government will continue to recognize this document as proof of being a beneficiary, but the holder also has the option to go to the Spanish National Police Station and apply for a new residence card. We will see an example of this new residence card issued in the next slide, but all that will be needed for this group is to set up an appointment and apply for the new card with a valid passport, the EU registry certificate, City Hall registration certificate in case of change of address, and 2 ID size photographs. During the first 5 years of residency, the holder will be granted a residence card with a 5-year duration. If the holder has already been residing in Spain for over 5 years, they will be granted permanent residency status with a 10-year validity. One benefit that the permanent residency holders under the withdrawal agreement have over other third country nationals is that they would be able to leave Spanish territory for up to 5 consecutive years without losing their Spanish residency rights and coverage under the withdrawal agreement. For UK citizens and family members who do not have an EU registry certificate, whether they did not process it before July 6, 2020, or they arrived after this date, an application before the Spanish Immigration Office is mandatory. The applicant must apply within the 3 months from the time of arrival to Spain, which must have been on or before December 31st, 2020. Otherwise, the withdrawal agreement is not applicable. The applicant must submit the application at the immigration office either with an appointment or via the application submitted electronically by an authorized lawyer, along with a copy of a valid passport, the boarding pass to Spain, proof of economic means, either by working in Spain or a bank certificate and private health insurance, and a Spanish city hall registration certificate, known in Spanish as empadronamiento, proving that the applicant had a residence in Spain before the end of the transitional period. And of course, any accompanying family members will require recently issued birth and marriage certificates translated to Spanish. The application takes up to 3 months to be studied by the immigration office, and once approved, the applicant may go to the Spanish police station and apply for the residence card. Here's an example of the card you'll see on the slide here, which will be the same regardless if the holder had an EU registry certificate or not. Family members of British citizens also benefit from the withdrawal agreement. For minor children born before Brexit or even after Brexit, they will be eligible for the residence card under this regime. For spouses, they can also join the applicant if they were married prior to December 31st, 2020, and residency is processed at the same time as the main applicant. Otherwise, from January 1st, 2021 onwards, they will need to follow national immigration law to join their spouse residing in Spain. For those arriving to Spain post-Brexit, the current legislation for third country nationals will apply. New arrivals will require work and residence permits and visas, as well as student permits and visas in case of studies. The main implication of this is that if you are considering hiring a British candidate, but they did not move to Spain on or before December 31st, please start planning the work and residence permit, as well as keeping in mind that the employee start date will be later, pending the approval of the work and residence permit. Additionally, inherent in Brexit is the finalization of free movement from one EU state to another for British citizens. From now on, any British citizen, including those included in the Brexit regime, must obtain the corresponding work and residence permit if they wish to move to a different EU state, following local immigration laws. There are, however, a few options that allow mobility and employment in other EU countries for third country nationals. For the sake of time, please feel free to shoot me an email to clarify information on these options and the conditions required to process them afterward, because just these options by themselves would require an entirely separate webinar, but I did want to mention them. First of all, we have the Van der Elst visa for secondments for third country nationals living and working in the EU already. The EU long duration residence card, which allows the holder to move to another EU country with a simplified procedure and obtain permanent residency there. And the EU ICT work permit for assignments to the EU from outside the EU, which allows working temporarily in other EU countries for companies which form part of the same group. As for British visitors to Spain for tourism and business purposes, they do not require a visa, but they are limited to a stay of 90 days in a 180-day period, and work is not allowed under any circumstances without the corresponding work permit. Additionally, we have to keep the current restrictions from COVID in mind. Under the current travel restrictions, the UK no longer is included in the exceptions allowing travel to Spain, as it is no longer part of the EU. As a result, to be able to travel, the individual must have a residence visa or permit, or have a letter issued by the Spanish Consulate in the UK demonstrating the urgency to travel at this time. The immigration procedure in the UK has been clear-cut for EU citizens moving to the UK and obtaining post-Brexit immigration status, but we will go over the options, especially as the applications can still be submitted at this time. First of all, settled status, also known as continuous residence, is granted to EU citizens who have been residing in the UK for at least 5 years. This is basically the equivalent in the UK of permanent residency. For those who have not reached 5 years in the UK, they are eligible for pre-settled status. To obtain this status, the individual must have moved to the UK by December 31st, 2020. With this status, upon reaching 5 years of residency, the applicant may also obtain settled status for greater security in terms of immigration. The deadline to apply for UK residency is June 30th, 2021, but again, only for those who were residing in the UK by December 31st, 2020. Just as under the Spanish Brexit regime, EU citizens in the UK also maintain the same rights to reside, to work, to study, and to use NHS as they had before Brexit. For new arrivals, the UK also requires visas for EU nationals for any employment or residency. Recently, in fact, the UK immigration authorities have redone their immigration program, applying a points-based system for local hires, which requires a B1 level of English and highly skilled profile, position, and salary. The intra-company visa option, allowing assignments between companies part of the same group of companies and not to clients in the UK, does not require any English language qualification, but it also requires a higher salary threshold of £41,500 and a graduate skill level. We've received a consultation regarding the activities permitted under the standard visitor entry, which means traveling to the UK without a visa, without needing a work permit. To summarize, no work is allowed with a standard visitor entry. The individual may, for example, attend meetings and conferences, give speeches under some circumstances, negotiate, carry out site visits and inspections, provide internal training to the UK-based company only if they are part of the same group, and to be briefed on the requirements of a UK-based customer, provided any work for the customer is then done outside of the UK. All other activities, especially any work completed in the UK, requires a work visa and meeting the specific requirements to obtain it. Social Security has been an aspect that we have found to be greatly overlooked while discussing Brexit implications, but perhaps one of the most important. The most discussed topic toward the final days of 2020 in terms of Brexit was the EU-UK Trade and Cooperation Agreement and the European Union Act of 2020 and the resulting protocol on Social Security coordination between the EU and the UK. This protocol maintains many of the same coordination agreements as per the EU Regulation 883/2004. It is worth mentioning that the protocol does not include Gibraltar, but the Spanish legislation in relation to Social Security post-Brexit does, which we understand means a specific agreement with the UK for these measures in Gibraltar will be pending. As a quick refresher on the main points of the EU regulation on Social Security, let's go over a few basic definitions that apply across the EU, the European Economic Area, and Switzerland in terms of Social Security. First of all, we have the principle of single applicable law. This means that each beneficiary is covered by the legislation of one country only and pays contributions in only that country. Secondly, exportability. Social Security benefits can be paid throughout the Union and prohibits member states from reserving payment for people resident in that country. Finally, aggregation. The aggregation principle means that the competent member state must take into account periods of insurance and employment completed in another member state. For example, this would be the case when requesting a benefit in France for unemployment. The Spanish contributions and periods will be taken into account. That said, it is important to keep in mind that this concept only applies to reaching the minimum time of contribution for the benefit, but it does not necessarily count toward the benefit itself in terms of amounts. To summarize the benefits and principles of the EU regulation, the coordination between EU countries is key. especially in terms of the minimum periods required for certain benefits, such as pensions, unemployment, disability, invalidity, sickness, maternity leave, etc. Thanks to the protocol, this will continue to be the case for Social Security benefits between the EU and the UK. Additionally, the protocol confirms that Social Security contributions are only possible in one state, thereby eliminating the possibility of double contributions between the EU and the UK. This is important for employees, whether British or any EU nationality, who have worked in several EU countries and the UK, as well as for any assignment, because the time worked in any of these countries counts to receiving the benefits in a different state. Just the other day, we had a client reach out to us. They have an employee, an EU national, but she spent her entire career working just in the UK. Now she's moving to Spain, but she's pregnant and she's actually due soon. So of course the company was concerned about whether she would be able to enjoy her maternity leave and benefits in Spain. And thankfully, as a result of the protocol, she's still covered as the minimum waiting period is met by her contributions in the UK, and will be able to enjoy her benefits in Spain, provided she obtains the corresponding documents from the UK recognizing these benefits and these periods. Same thing would apply for unemployment and the other benefits mentioned. For pension requirements, the time employed in other EU countries and the UK is included in the calculation of the minimum period required for retirement, which is important to protect the time contributed in the UK and the EU in the past and for post-Brexit. The protocol will continue to recognize this coordination. However, as we mentioned previously, regarding this concept of aggregation, this does not mean that the amounts contributed will be included in the final pension calculation. The EU regulation on Social Security establishes coordination, but not a common Social Security system. The reason the amounts contributed are protected under the EU regulation is due to the right of free movement in the EU. This right of free movement translates into the premise that an EU national should not have the amount of his or her pension impacted by the fact that he or she has lived in another EU member state. In other words, he or she must receive a pension with the same amount as if he or she had never left that country. And to obtain it, it is indispensable that the contribution amounts are maintained at the same level the employee was contributing for before he or she left. However, after Brexit, the right of free movement no longer applies for the UK. So it remains to be seen how the pensions will be calculated, but we do not rule out that the contributions will be calculated with the minimum contribution base instead of the integral amounts. And because of that, we recommend Spanish nationals working in the UK to subscribe to special agreements with Spanish Social Security to protect their contributions for retirement. The protocol is valid initially for 15 years, during which time new arrangements may be made either between the UK and the EU or the UK and individual member states. Notably, the protocol does not include medical and social benefits, just as the case of the regulation. This is from the fact that each EU country determines the right to healthcare differently. In the case of the UK, it is based solely on residence in the UK. For Spain, it is based on contributions to Social Security. This is important because, as we will see in the next slides regarding healthcare, the protocol does not include public health assistance necessarily. For posted workers assigned to Spain, these employees will enjoy the protocol benefits described via the A1 form, which is the certificate demonstrating that Social Security obligations are maintained in the home country and notifies the assignment to work in a different country. The employees can be seconded for up to 24 months, and the minimum contribution period for these benefits are maintained as long as the UK shows reciprocity. Please note that this is different from the EU Posted Workers Directive, which will no longer apply to British citizens. Instead of this directive, British citizens must apply for the corresponding work and residence permits. Healthcare, again, may seem to be a minor point in the Brexit agreements, but after reviewing the legislation implemented in Spain, we see that it is not as clear as the withdrawal agreement and the Spanish government's press notices may lead us to believe. First of all, healthcare for local employees and visitors from the UK to Spain. These groups have a very clear situation. Obviously, for UK citizens residing and working in Spain with a local work contract and contributions, they will continue to benefit from public healthcare in Spain. Even for post-Brexit arrivals, for employees with a local work contract, they will maintain the right to public healthcare after the minimum waiting period is met, which is 6 months. Likewise, for visitors, the agreements allowing traveling under the European Health Insurance Card, while valid, or the new card issued by the UK called the UK Global Health Insurance Card. These cards will continue to allow emergency healthcare when visiting the UK from the EU or visiting the EU from the UK. However, the authorities still recommend holding separate travel insurance to be covered, for example, for repatriation and for special rescues. As for healthcare for pensioners and posted workers, we see a lot of uncertainty at the moment. These two collectives will require a valid S1 forms, which is the form issued by the individual's home country Social Security Administration, or the NHS in the case of the UK, confirming that they will be responsible for public health care in a different EU country or the UK. However, the S1 forms will only initially be recognized in Spain until June 30th, 2021. Pending, in any case, reciprocity from the UK. So despite what the Spanish government has indicated and the withdrawal agreement, what does this limit actually imply? It means that until the end of June, there is time for a new agreement between the UK and Spain to cover healthcare, or in absence of an agreement and without reimbursement, there will not be any public health coverage for British citizens in Spain without contributions to Spanish Social Security, resulting in the necessity to hire private health insurance. Between now and June 30th, the posted workers and pensioners in Spain will continue to benefit from public health care in Spain as per the conditions before January 1st, as long as they have the public health card or at least the valid S1 form. However, reciprocity is still required. The UK will need to reimburse the medical costs in Spain of those benefiting from the S1 form, as well as cover the Spanish citizens in the UK under the same circumstances. If the UK does not do so, the public health care for pensioners and posted workers will end on February 28th, 2021, which is 2 months after the finalization of the Brexit transition period. Finally, the recognition of professional qualifications of UK degrees in Spain. As you may know, some professions, for example, doctors, lawyers, etc., require official recognition to work under that official capacity in the country where they reside and work. Other employees do not require this recognition procedure, nor the homologation procedure. If the professional's degree is from outside of Spain, a simple recognition procedure is required for degrees from EU countries for EU citizens, whereas a complete homologation procedure is required for those from outside of the EU, which takes much longer and requires additional documentation. If you initiated the recognition procedure prior to the end of the transition period and you benefit under the Brexit regime, the procedure includes those applications already in process, as well as new applications, including students who have initiated their studies before December 31st, 2020, for 5 years following this date. The homologation will be required for those professionals wishing to work in their profession after this 5-year transition period. This is a longer procedure and requires more detailed documentation. At this point, that about covers all the main points we're going over today. But I would like to go over the main points that I would want you to take away from today's webinar. First of all, make sure you, your family, your employees, whatever the case may be, initiate the residency as beneficiaries of the withdrawal agreement if applicable. As a reminder, this would be for those who arrived to Spain on or before December 31st, 2020. For others arriving after January 1st, initiate a work and residence permit procedure as soon as possible to avoid delays for employment start dates. Second of all, if you are a posted worker and moved to Spain before the end of the transition period with the A1 form, you can continue your assignment through the end of the initial secondment period. Third, for pensioners and posted workers, please process your registration for public health care with your valid S1 form at your corresponding Social Security office and Spanish Medical Center to enjoy public health care benefits. However, please remember that they will only be valid at the moment through June 30th, 2021 at the latest, unless a new agreement is made between Spain and the UK. So please look out for updates. Finally, if applicable, please request recognition from the corresponding professional association, taking advantage of the 5 years permitted to do so. Thank you for your time today. We'll now go into questions. Any that I cannot get back to or are more specific, please contact me afterwards to discuss further. And if you're interested in receiving new information about Brexit, and especially as news is released in terms of Social Security and public health care coverage, please follow GD Global Mobility to receive our updates. Thank you.
Thank you to you, Linnea, and thanks for the summary exercise of an issue as complex as Brexit. We have a lot of questions, so come on. The first one. First one is from Eva. Eva says, could someone who has only worked a few months in the UK in 2020 with a Spanish employment contract and fixed residence in Spain can apply for the pre-settled status?
And they arrived in 2020. If they're residing currently, they would be eligible initially for pre-settled status, exactly, because they moved before the end of the transition period on December 31st, 2020.
This one from Dolores, I prefer to send it in Spanish. I think it's very complex. Dolores says, en su opinión, los artículos 4, acceso y ejercicio de la profesión, 6, sobre desplazamiento, 8, prestaciones de desempleo, 9, ley aplicable a la seguridad social, 11, acceso a la asistencia sanitaria del Real Decreto Ley 38/2020, entraron en vigor el 1 del 1 de 2021 a pesar de la publicación en el DUE de 31 del 12 del Acuerdo de Comercio y Cooperación entre la UE y el Reino Unido para estos temas en Protocolo de Seguridad Social. Parece razonable que entre en vigor respecto de Gibraltar, que quedó al margen del acuerdo, pero en el resto de los casos, esta pregunta también está formulada en inglés, pero es que es complicada trasladar, por lo menos para mí. Yo he hecho ya mucho esfuerzo.
No worries. So we actually consider that the Royal Decree law from December by the Spanish government and the Protocol on Social Security are both effective. Because it's basically the protocol sets the agreements in terms of Social Security coordination, which, as we discussed, is basically the same as the EU directive on EU regulation on Social Security. Whereas the Spanish Royal Decree law covers more specifics until there is a specific agreement in terms of, the healthcare and those issues that aren't covered in the protocol. And so that's why we're still waiting for updates. For hopefully a new agreement will be made soon and we'll have greater clarity.
Next question is from a photovoltaic energy company. And they say that they sometimes need to send personnel for repairs or reviews, short-term trips, or for the constructions of new plants, long-term trips. For short-term maintenance works as well as trips for commercial visit, we understand that we do not need to apply for visas, but that for long-term we do?
So that goes back to what we briefly mentioned before regarding the trips to the UK. And so basically with a standard visitor visa, only certain activities are allowed. So for example, business meetings, and if they were to go and review the installations of the client, or to go and understand in greater detail the needs of the client, that would be allowed under basically the visa waiver entry to the UK. But anything beyond that, so for example, any repairs, if it's done physically in the UK, as well as construction, will require the appropriate visa. If it's a client company, we need to look at the case in more detail, but it would probably be a skilled visa, which is the point-based system. Or if it's to a company in the same group of companies, that would be the intercompany transfer visa.
Okay.
Which has a higher salary threshold requirement, but it does not necessarily require the English qualifications.
Okay. Next question is from Imma. Imma es que se me va. Perdona, que hay un montón de preguntas. A lot of questions. Okay. Imma, if a person is residing in Spain before December 31, 2020, but has not applied for residency under the withdrawal agreement before 31 December, can still apply for resident under the withdrawal agreement, showing that he was residing before the end of the transitional period?
Exactly. The key thing there is to show, once again, the boarding pass showing that they traveled to Spain before December 31st, 2020, and that they have some sort of residency. Ideally, they need to have the City Hall registration certificate, the empadronamiento, but if they just have a rental agreement or something similar, they should present that as well, showing that they had a residence established in Spain before the end of the transition period. And once again, the time limit is 3 months from the time of entry to Spain. So even if the person had entered Spain on the 31st of December, they can still apply within the following 3 months. And actually, even it's a little bit flexible as long as they were to prove in that situation that they couldn't submit the application earlier. But in that situation, definitely the person would be able to benefit from the withdrawal agreement.
Another question regarding Social Security. Currently, the document TA 300 had to be processed to communicate the displacement in the European Union. Now, how is this managed? This is from Eva.
So within the EU, that would still be with the TA 300 form, which the secondee would then be granted the A1 form, which is what would need to be presented in the destination country, showing that they are contributing to Social Security in the home country. At the moment, that continues to be applicable for any assignments between the EU and the UK. So it'd still be the TA 300 form, and they would receive the A1 form.
And what about Social Security contributions? Will they be recognized in Spain for benefits purpose?
Exactly. So that's the huge benefit of the protocol, is that looking at the protocol, it's almost word for word the same as the EU regulation that we mentioned earlier, 883/2004. Which recognizes the coordination and account the time spent working in other EU countries to see the benefits in terms of pensions, unemployment, maternity leave, etc.
Guillem wants to, he says, would you mind to repeat changes for people going to UK for business purpose? Valid passport is enough?
At that point, it'll be just as a visitor, so they would need the valid passport, proof of lodging at a hotel or an apartment of some sort, proof of economic means, travel health insurance, as well as the proof of what they will be doing there. So perhaps a letter from the companies involved explaining the business meetings that they have in the UK.
This is from Connie. This is Connie from Nara. If a UK citizen wants to visit Spain for 1 week, do they have to get the letter from the Spanish consulate in the UK?
At the moment, yes, I'm afraid so. With COVID, As I'm sure many of you know, a lot of travel is limited, and the exception to travel to Spain was actually in place for all EU nationals and citizens and residents. And so, since the UK is now out of the EU, they no longer benefit from that. And so, at the moment, they are not allowed to travel, and that's also beyond the fact with the recent border closures with the UK. And so for any third country national who is not included in the exceptions, they require this letter from the consulate to be able to travel.
Nescuts wants to know what should a posted worker apply for regarding Social Security if posting is after 1st January 2021?
So in that case, they should still process the TA 300 form to then receive the A1 form. They still would be eligible at the moment to apply for the S1 form. Obviously, as we discussed, there's a lot of uncertainty in terms of healthcare, but at the moment they would still be able to process that. And then as they be seconded after January 1st, 2021, they will require a work and residence permit to be able to work and complete the assignment.
This is from Lucia. If I want to hire an intern this year here in Spain, he is a UK citizen, he would need to apply now for a permit to live and work. And if this the start date is in April, are we on time to apply or delay is probable?
I understand in this case that he does not benefit from the withdrawal agreement since he is outside of Spain. So that means that, yeah, to complete the internship, he will need to apply, or the company on his behalf will need to apply for what's called a residence authorization for interns. Depending on where the company is located in Spain, this permit can take anywhere from about 1 month to even 3 months. And so I would say that Lucia, you should start immediately looking at the options to apply for the permit to make sure that the permit is granted in time, and also to make sure that the intern has time to apply for the residence visa in the UK.
Okay, Francesca wants to know, can someone with a settled status and self-employed in UK move to Spain and have access to the Spanish healthcare system, or how does it work?
In the case of settled status in the UK, I understand that they are a Spanish citizen or an EU citizen. In that case, if they were to move to Spain, obviously they would need some sort of residence permit. And if they are a pensioner of some sort, or if they're employed and they're seconded to Spain, then they would be eligible to count the contribution periods for unemployment or other benefits. If there's not that relationship, then they wouldn't necessarily be covered for those benefits in Spain. We need to look at the situation in a little bit more detail with more information.
Okay, this question is from Raquel. Before Brexit, our company sent 2 or 3 workers to work in UK for 2 or 3 months. In Spain, it's called desplazados. They worked for the Spanish company, but in London. Now these workers need a visa? And what visa? What kind of visa?
If they are in the UK now, and they arrived before the end of the transition period, they would be, we'd have to look at it, but in general, they should be able to benefit from the withdrawal agreement and would be able to process pre-settled status. Obviously, I would hope that their A1 forms and everything are in order, because otherwise they wouldn't be able to work legally in the UK. And if they are arriving now after January 1st, they would need to process a work visa. If the work completed in the UK is for a company within the same group of companies, they would be able to process the intra-company work visa, which would allow them to work for a company in the same group. If it's for a client, then they would need a work permit where the client in the UK is the sponsor and meet the requirements for that work visa.
Okay. Inma question, until when a family member British of a British citizen that has applied for residency under the withdrawal agreement before December 31, 2020, can apply for residency under the withdrawal agreement as a family member if they enter after January 1st, 21, Is there a time limit to enter Spain to benefit from it?
For minor children, so under 18, there is not a limit. But for spouses, the limit was the 31st of December, and it was mandatory to process the permits at the same time as the main applicant. So if it is the spouse, they would no longer be eligible to benefit from the withdrawal agreement, and they would need to process either a reunification visa or a different visa for the spouse in their own right, whether in terms of residency or employment in Spain.
Okay. Sylvia wants to know which is the process now for an English firm to hire a Spanish worker for work in the UK?
The application is submitted online. They have to be registered at the UK immigration authorities. And basically, they would need to prove that the candidate meets the requirements in terms of the English language qualifications, either with an English language exam, or they studied and have a university degree from English-speaking university, as well as terms of the salary received, the profile, the work to be completed in the UK, and process the work visa directly from there.
Okay, Lucia wants to know what are the costs for employers on this on work permits?
I don't quite understand the question.
Now, what are the costs for employers on these work permits? ¿Cuáles son los costes para los empleadores del permiso de trabajo? Entiendo yo. Si Lucía está conectada, que sí está porque no ha salido,
Yeah,
si puede aclararnos la pregunta.
Obviously, for in terms of government processing fees in Spain, the cost, depending on the permit, goes from around 90 euros up to 400 euros, depending on the type of permit.
Which is the official website for applying for working visas?
In Spain, it depends on the type of permit, but it would either be the unit for strategic sectors and large companies, which is UGE, UGE. Otherwise, it's the Spanish Immigration Office, Oficina de Extranjería, of the province where the company is located in Spain.
Okay, and the last one question is from Jennifer. Please, can you repeat why it's convenient for posted Spanish employees to establish agreements regarding pensions with the Spanish Social Security?
Yes, of course. Basically, because it is unclear with the protocol, the Social Security protocol, how the pensions will be calculated post-Brexit. So with free movement, all the employees who are seconded and had worked in different EU countries basically maintained their contribution base before moving outside of their home country. And so if now an employee is seconded to the UK or directly are working in the UK, that doesn't mean that their contribution base will be protected when they do return to Spain and when they need to calculate their pension for retirement. And so the special agreement with Social Security protects that minimum contribution base to make sure that they don't have lower contributions than what really would pertain to them. And so that would protect the Spanish nationals in that case.
Has arrived another one from Eva Maria. Eva Maria wants to know which documents are needed to post workers who are hired in Spain and have to work in UK.
So they would need obviously to process the TA 300 form to then get the A1 form. And then the assignment itself is to identify obviously the employer in Spain, the employer in the UK, and the individual themselves with their profile, the salary that they receive in Spain while seconded, to ensure that they meet the threshold necessary.
Okay, well, that's all. That's all, folks.
Well, I'm sure there's a lot more questions, so obviously they can shoot emails afterwards. Not a problem.
Okay, intense speech and complex questions. Permitidme que pase al español. He hecho un esfuerzo, de verdad. pero yo creo que, bueno, yo he aprendido y le he perdido el miedo a hacer estas cosas en esta segunda ocasión. Gracias por, por aguantar mi inglés así un poquito raro, pero gracias a ti, Linnea, por la charla, por el ejercicio de concisión, que es un tema, hablábamos antes de estar en conexión, hiper complejo, que tiene tantas derivadas que, bueno, pues no va a ser cuestión de pocos meses que nos lleve para adaptarnos. Gracias a todos por conectaros, mira, nos están diciendo que ha sido estupendo, que ha sido una experiencia súper buena el combinar ambas cosas, el tema del contenido con el tema del inglés. Así es que nada, haremos más sesiones como esta. Estamos a vuestra disposición. Os enviaremos tanto el vídeo de esta sesión como la presentación preparada por Linnea y intentaremos publicar también, incluso lo hablaremos con GESDocument, un repositorio de principales cuestiones que creo que sería interesante de divulgar. Un abrazo a todos y cuidaros, estéis donde estéis, cuidaros mucho. Un abrazo. Chao.
Muchas gracias.
Gracias a todos. Y gracias, María José, que me dices que tengo, a ti que tienes un acento súper bonito. Linnea, te dicen.
Gracias.
Chao, hasta luego.
Chao.